Thank you, Carol, for that very tall order you were given. Right, well, so next we have Celia Taylor talking about possible reforms to US securities law to compel climate change disclosure. Thank you.
Seating. I'm not feeling very well, and I'm hoping my voice will hold out for the length of this discussion. I want to thank Beate very much for encouraging us to have some hope in what is not always a very hopeful world out there, and to all the papers that have been presented that have given us opportunities to hope. I also, in a perverse way, want to thank my UK and Canadian colleagues for making me think that maybe the US is not absolutely the last in the world that might make some changes to implement climate change disclosure and concerns into company decision-making. That said, I think the challenge of encouraging or requiring United States corporations to integrate environmental sustainability into the internal workings of their corporations is significant. But Beate has encouraged us to dream, and so I will present what may be a pipe dream proposal, but at least theoretically possible. My comments will also, to a large degree, reflect some of the conversation on the earlier panel, so I will keep that part of it very brief. I'm going to put my proposal first and then explain where it comes from. I'm suggesting that if we are going to make any difference at all under US law, my proposal will call for mandatory disclosure, both of the impact that the environment may have on company behavior, which to some small degree is currently called for in US law, but more importantly, mandatory disclosure of companies' impact on the environment, which is currently not called for at all. Now, this proposal rests on two main premises, which we've been debating already, and this is where I'll keep my remarks quite brief. The first of the basic premises is that disclosure matters, both to investors and to company decision makers. And I've just written a paper called Drowning in Disclosure, so I'm very much on the bandwagon that we have information overload and that we have to be very careful. On the other hand, I do think that if we don't have disclosure, we have nothing, and therefore I continue to think that reporting is necessary and helpful. Which leads to my second premise, which is that disclosure must have real substance and must have a purpose behind it and content to it. So that goes both to the earlier discussion and some of the conversations we had yesterday about risk assessment models and how those might be meaningfully integrated into reporting requirements. So, mandatory disclosure, first of all, in the United States, we need to think about where that would come from. As Professor Millen discussed yesterday, most corporate law in the United States is state law, which each state designates the corporate governance rules for particular corporations, and Delaware leads the charge there for sure. My proposal is directed not at the state level, but at the federal level, where we have very little substantive regulation of corporate behavior. Instead, we have a model of disclosure regulation. Basically, do whatever you want, but tell us about it, for better or worse. Most disclosure regulation in the United States is drafted by the Securities Exchange Commission for complicated reasons. And it's interesting to note that the SEC has in fact spoken about climate change disclosure specifically. In 2010, they issued an interpretive release about what companies might include in their annual reporting and other reports with regard to climate change, which I want to talk about briefly because I want to talk in this proposal why I think the proposal needs to be mandatory disclosure, and then how I think this theoretically could actually happen in the United States. So in 2010, the SEC was pressured significantly by some large unions and, believe it or not, pension groups who thought that climate change was relevant to their investment decision making. And after a 3-year campaign, the SEC, by a 3-2 vote, there's a 5-member commission, it's very political, but at that time, 3 of the members decided that they would, in fact, promulgate this guidance, mentioning particular provisions of reports where climate change was relevant. A couple important things to know about the guidance is it's a voluntary reporting recommendation. It does not say to corporations, you must discuss climate change in these provisions of your reports. It simply says, here, if you're going to talk about it anywhere, here's where you might think about putting it in. So the areas that they mentioned specifically were the description of business. The item expressly requires disclosure regarding certain costs of compliance with environmental laws in that conversation. You were supposed to talk about climate change impact in legal proceedings. Importantly, what the SEC said here was that any proceedings that arise under rules or regulations regulating the discharge of materials into the environment or primarily for the purpose of protecting the environment shall not be deemed to be ordinary routine litigation, which need not be described, but shall be taken out of that category and be subject to disclosure requirements. Two other ones that I think are very relevant for purposes of the conversations we've been having over the past few days. The SEC said you should talk about climate change in your risk factors. Now, they said that risk factors disclosure regarding existing or pending legislations or regulations that relate to climate change should be disclosed. But I think as we move forward, we could expand our understanding of risk factors and what that really meant, which I'll talk about in a moment. Finally, they identified the management discussion and analysis, and this sort of goes to the integrated reporting we were discussing earlier. The idea behind management discussion and analysis is to provide a narrative explanation of the financial disclosures contained in the annual reporting. So it's an attempt to kind of meld together both the financial and a narrative combination and to make it more palatable and understandable to ordinary investors who aren't accountants and aren't perhaps familiar with the acronyms we were just discussing in the earlier panel that I frankly didn't know what each of them stood for, but the narrative discussion might have helped me on that front. So here we have the SEC in 2010 suggesting all these ways and areas in which companies should be thinking about disclosure relating to climate change, which seems quite encouraging. However, as also was mentioned in the prior panel, all of this was keyed off materiality, which we could have a very long conversation about what is materiality, who gets to determine materiality standards. But in each of the categories where they said disclosure was recommended, it was only if a company believed that the impact on operations would be material. So some studies were done after the guidance came out to determine if and what effect this guidance had on actual public reporting by companies subject to the SEC rules. And not surprisingly, the results were not perhaps what we would have liked. There was two theories that would happen. One is that we would get volumes and volumes and volumes of meaningless disclosure, which we've talked about before, or that we would get just total greenwashing, so that was one route that we might have gone down. Or the converse was that everyone would simply decide that climate change is too far in the future, not material for present purposes, and they wouldn't say much at all. We had a little bit in the middle. We certainly did not get information overload. In the first years after the guidance came out, only 20% of publicly reporting companies addressed both the regulatory and physical risks from climate change. Now, that may have been more than did it before. There wasn't really much research that went on before the guidance came out, but 20% is not exactly information overload. Only 24% of the companies who talked about it at all addressed the physical risks to their assets. Wow, time does fly. So let me speed up. Very little disclosure of actual or potential reputational harm, which we also have been talking about a little bit in here. That was immediately after the guidance came out, so there was some theory that, well, maybe companies just needed time to understand what was being called for and that would get better as time went on. Unfortunately, it did not. It got worse, and the most recent report that looked at most recently filed annual reports, a report of almost 4,000 filing companies found that only 27% mentioned climate change or global warming in their filings. So clearly, the volitional nature of this guidance is saying to companies, well, don't really worry about it. It's not that important. You can do it if you want to, but it's okay. Which is why I believe we have to make it a mandatory reporting requirement. How would this happen? Well, in reality, I'm not sure it ever can, but theoretically, when we are encouraged to dream, here is how I dream. The SEC could act of its own volition to mandate rules requiring the disclosure of climate change. As an independent agency, they have the authority to do that. My optimistic note is within the last year, the SEC has recognized climate change as a significant policy issue, which is a huge step forward for the SEC. It's not relevant to disclosure matters, it's relevant to shareholder proposals, but that is at least indication that the SEC is taking this seriously. The second way this could happen and to make disclosure mandatory is that Congress could require the SEC to draft rules regarding climate change. And then even if the SEC didn't want to do so, they would be statutorily mandated to do so. I think that is even less likely than the SEC acting of its own volition. However, I will also say on this note, it only takes one politician. We have examples of other disclosure regimes being, I hate to use this kind of pejorative term, but I will, snuck into legislation and being passed. I'm thinking specifically, Marcia is very familiar with this, of the conflict minerals provision requiring disclosure about the sourcing of materials out of the Democratic Republic of Congo, which got put into the Dodd-Frank requirements, and nobody really knew they were there until all of a sudden they were the law. So if we want to be subversive, we could try to sneak mandatory disclosure about climate change issues into some other bill that was going through Congress and hope nobody noticed. But anyway, I would like to see us do it in a more principled fashion, clearly, and recognize the importance of it. My belief that that will happen is slim, but I'll take it any way I can get it. Thank you.